But before we get to the intros, I'd like to recognize our sponsors. First, the gold sponsors, B. Riley Advisory Services, First Business Bank, Capstone Headwaters, Great Lakes Business Credit, Crestmark Bank, Kerr Russell Law Firm, Plunkett Cooney Attorneys and Counselors, Dickinson Wright Law Firm, McDonald Hopkins, DWH, and O'Keefe celebrating their 20th anniversary. Our silver sponsors, Advanced Manufacturing Group, Jaffe Raitt, Alex Partners, M-Bank Business Credit, Conway McKenzie, Miller Canfield, EDSI Consulting, Morris Anderson, Harmon Partners, Harney Partners celebrating their 30th year in business, Plant Moran, Hilco, and Varnum. And our bronze sponsors, Friedman Real Estate, Great Rock Capital, LE Law Firm, Newpoint, Oxford Bank, Spectrum, Schaefer Weiner, Strobel and Sharp, Tab Bank, Drakeage Law Firm, and Wolfson Bolton. So with that, we'll get into the intros of the panel members. And John, do you want to kick the intros off?
Yeah, good afternoon, everybody. My name is John Lucas, and I'm a partner at Pachulski, Stang, Ziehl, and Jones, which is, I think maybe the best way to describe it, a bankruptcy boutique that has offices in New York, Delaware, Texas, Los Angeles, and I'm based in San Francisco.
James?
Good afternoon. I'm James Morden with Capstone Headwaters in the Financial Advisory Services group there, primarily focused on restructuring and turnaround activity.
Paul Neitzel.
Good afternoon. I'm Paul Neitzel. I'm with Rock Creek Advisors. We are financial advisors. We also assist in bankruptcies, assignment for the benefit of creditors, liquidating trusts, and other restructuring matters.
Thanks, Paul. Robert?
Hi, I'm Robert Hersch, Managing Director for Mastodon Ventures. We are an M&A advisory firm solely focused on the restaurant industry, representing both distressed and turnaround situations, as well as healthy companies.
Thanks, Robert. And finally, Paul Hage.
Hi, I'm Paul Hage. I'm a bankruptcy attorney at Jaffe, Raitt, Heuer, and Weiss. And in the BarFly cases, I was co-counsel to the Unsecured Creditors Committee along with the Sugar Felsenthal firm out of Chicago. Nice to see everybody.
Thanks, Paul. So we'll start out with Paul Neitzel. Question to you, Paul. So our audience has a complete picture of what led up to the filing. What was the state of BarFly's business prior to the pandemic, and how did it impact BarFly?
Okay, and thank you, Sheldon. I will give a brief background on BarFly. They were founded in 2008. They're the parent company to HopCat, Grand Rapids Brewing Company, and Stella's. Like a lot of restaurants or a lot of concepts, initially the first few locations, stores or restaurants were successful. And with that success, the company chose to grow the brand in new locations and in size of the restaurants. The challenge of HopCat or BarFly is that each of their restaurants has a unique design, and they are known for the wide variety of beers on tap with over 80 local, domestic, and international beers. Their new locations outside of the Grand Rapids area or outside of Michigan included Minnesota, Wisconsin, Nebraska, Indiana, Kentucky, Illinois, Missouri, and Florida. They financed their growth, and when a few of the new concepts or the new locations struggled, they were not able to service their debt. Prior to going into bankruptcy, they closed a couple locations in Florida and Chicago. And then as news of the COVID-19 was spreading in the early part of 2020. They were really at a crossroads on what to do. They eventually shut down operations in late March 2020. They furloughed their 1,200 employees, and they started looking into what we will describe later as the PPP loan under the CARES Act. They eventually decided to file for bankruptcy on June 3 of 2020.
This is Paul, I just wanted to add a point here, and that is, I really don't think it can be overstated how successful, at least from the outside, HopCat was in Michigan, putting aside distinguishing from other states. But it was a big deal for those of us who are in Metro Detroit. It was a big deal when locations opened up in downtown Detroit and Royal Oak. It was something that, you know, was in the papers because it had been so successful in various cities in the western part of the state. So it was I think a very big deal in Detroit and in southeastern Michigan.
Yeah, in their
when these
backyard.
restaurants opened.
Right, in their backyard, they were very successful once they spread out to say St. Louis, Chicago, Port St. Lucie, Florida. They didn't have the notoriety of the new restaurants opening.
Right.
Do you think that the expansion affected them in terms of that notoriety that you just mentioned? And were there, what was the largest, most pronounced operational issues that they faced during the bankruptcy?
During the bankruptcy, it's very unique because they were trying to operate while the state of Michigan had closed down restaurants. So they, prior to closing down in COVID-19, they hadn't really focused on takeout or delivery. They dipped their toe in the water on that initially at the onset of the restaurants closing down, but they found that they were burning cash at that point. They pulled back on that and just decided to mothball operations until they could find a clear path to reopen.
The difficult decisions that so many restaurants and small businesses had to make about a year ago at this time. What do we do?
Yeah,
Right.
without any visibility to the future.
Right.
And one of the things that most or all of the restaurants had to face was dealing with their landlords. Landlords, whether it be in restaurant, retail, or otherwise, behaved in a variety of ways when COVID hit. Paul, given what was happening in the restaurant industry, did you find that the landlords for HopCat were open to negotiations?
Yeah, I would say initially the landlords were very helpful and understanding. And it's not like we were dealing with just a couple of landlords that had maybe 10 to 20 to 30 leases. Each lease was held by an individual landlord. And things changed a bit once HopCat or BarFly received the PPP loan, because the landlords understood that process as well as we did. So they knew that a portion of that money was earmarked for rent. So that made negotiations a bit tougher. Our focus was to move landlords to a variable rent type of situation, because we didn't really know what was going to happen with COVID-19 and the reopening of restaurants, or a second wave or a third wave in the future.
Sure. So let's take a minute and shift to the legal perspective, John. As you saw it as counsel to the debtor, what was a key issue that resulted in the Chapter 11 filing?
Well, I think that there were a couple of things, and you know, one of the primary ones was, you know, dealings with the landlords. But before I'm going to get to that, I'll say, sort of from a larger perspective, you know, as Paul had mentioned, the company did really well in Michigan, in the surrounding area. It was well received. The locations were operating on a positive basis, and so, you know, it was just great. And so they expanded and went into, obviously, areas where it wasn't as well, the concept wasn't as well received. And in doing that, you know, they became, you know, very over leveraged. I think that when the bankruptcy was filed, the company had about 30 million in pre-petition debt, and it was unable to service the debt and obviously and deal with its ordinary course operations in a profitable way. You had profitable restaurants subsidizing basically the restaurants that weren't able to operate at a profit, and so it was just sort of a losing enterprise if you were going to keep all the locations afloat by having the successful ones make up for the shortfall of the ones that aren't successful. And so I think that was sort of the first thing. But the company saw that it needed to get rid of some of the unsuccessful or the unprofitable locations, and it was trying to exit those locations on a consensual basis with the landlords. And so there was litigation involved with those landlords, and so long as they weren't going to get a judgment or execute on company assets, it didn't really matter. It was just trying to sort of manage those properties and keep them at bay, and to minimize legal cost and make sure that the cash that the company had could be used for things that were going to be building on the future. But with that, and as Paul Neitzel had mentioned, trying to engage the landlords in sort of this really sort of unknown territory that we all found ourselves in, what was going to happen next week or next month or this summer, and were restaurants even going to be open? I think that some of the landlords were also in a difficult situation because they too had their own lenders, and they relied on the rent or the triple net sort of pass through come through to help them service their own debt. And so I think that the lenders here, and that might be sort of a different situation than maybe some of the other bankruptcies here, because I think that I think the COVID had this effect across all industries. I mean, obviously the restaurant industry was hit hard, but it impacted and sort of rippled across all industries, going to the landlords and to their lenders and stuff. And so everybody was feeling the crunch, and so there wasn't a lot of flexibility anywhere. But in the end, what caused the bank, I got a call, and I first talked with the founder of the company, I think the Sunday after Thanksgiving in 2019. And as they said at the outset, the company filed on June 3rd. And so there was about 5 months of sort of dancing with the lender, looking for solutions, looking for out-of-court solutions and other sort of potential buyers or equity infusions to help sort of recapitalize the business so that it could have the capital to move forward. But the biggest thing was, once you identified the locations that were keepers and that they were part of a successful business going forward, we needed to make sure that those leases weren't going to be terminated. And we needed to do everything that we could to negotiate with those landlords, and in the end, to restructure those leases. And so I believe it was in early May that the company got a PPP loan of about $6.8 million. And all at that same time, the company was sort of mothballed. And so we were better positioned to try to deal with the landlords. But ultimately, we had one location, which was the Royal Oak location. And the landlord was able to terminate the lease, and it was a profitable store. And so at that point, we had advised the board that you can't take any more chances with that. You can't lose any more locations, and that it will be absolutely necessary to file a bankruptcy case because you're not going to have any business to restructure if you don't have leases from which to operate the business. And so that was really sort of the leading point of protecting those locations, and then ultimately filing to protect those locations. And there really wasn't all that much discussion with the lender, which is somewhat unusual before you go into the bankruptcy. And all the discussions with the lender, which was ultimately the owner of the company, took place post-petition, and it was a little bit rocky at first. But I think everybody here on the team eventually hit our stride with the lender and got a deal done. So.
Thanks, John. Don't want to jump ahead here to the end, but we all know that, each of these stores had liquor licenses, and having been a receiver in a case where I sold the liquor licenses, I know the transfer of those licenses can be cumbersome. But in this case, and maybe in bankruptcies in general, how does the transferring of the licenses, how did it complicate or not complicate a 363 sale?
Well, I think I think that when you're selling a business that has something like a liquor license, it tends to make the transaction take longer and ultimately maybe be a little bit more expensive. I'm not sure exactly about our audience today, but I mean, under the bankruptcy code, there's a section that allows a debtor to assume and assign contracts and leases over the objection of the counterparty. But liquor licenses are different. They don't fall in that bucket. And so you don't have that sort of magic wand that the bankruptcy code can enable a company to do that. In part because you require, local authority authorization to even sort of take hold of the license to make sure that, you don't have a criminal record and the company's well capitalized and stuff like that. And so there's a huge, basically, latency period. Like you could have a deal and they're going to take all your licenses, or they're going to step into the shoes of the new licenses and remove the old one. It can take a month in some cases, and sometimes it can take up to 6 months. And it's a problem because you can't have the bankruptcy case sort of open during that time because of the cash burn, and have the debtor operating the business. You're going to want to transfer the business, and then you need to do some sort of transition services agreement where the debtor continues to hold and to purchase the license really for the benefit of the buyer, while the buyer is getting its own licenses, or the licenses are getting transferred in a valid manner. And that is a little bit could be potentially problematic because you're relying on this purchasing entity that sometimes is just a shell. It might not be all that well capitalized, and it is really assuming all the responsibility for anything that is could happen from, let's say, a drunk driving incident or something like that. And so that whole period is a little bit, a little bit nerve-wracking a little bit, because you're dealing with, like I said, a newly formed company and also a bankruptcy estate that has a finite amount of cash.
And you have no control over how long it's going to last. It's somebody else's hands.
Yeah, and in this case too, and Paul Neitzel can correct me if I got some of one of the locations had a brewing license for beer, and that license wasn't from the state, but it was from the feds, and that one took the longest out of them all. I think it took well over 6 or 7 months or something like that for that to get transferred.
Yeah, the brewing license was the most difficult. The liquor licenses were, I think, 4 to 6 weeks. But yeah, John Lucas is correct. And with that, you need to, for the bankruptcy estate under the TSA or the Transition Services Agreement, you'll need to keep all those insurances in place, as John alluded to.
So John, well, this case had many of the same issues that many Chapter 11 cases have. What was something different that, if we didn't address it, could have prevented a successful outcome?
Me.
Yeah.
And what I mean by that is it's really sort of all the professionals, really. And I think that we all really worked well together. And I think that we saw what it was that we were dealing with. Like our patient, so to speak, was fragile. It had a limited amount of cash and it had a limited amount of runway. And I think that we all saw that. And I think that we had to treat it very sort of carefully and make sure that the case wasn't over litigated. We didn't get sort of caught on some like frolic and detours. And as a result of that, we were able to keep the professional fees down and at a very sort of modest level. And, and the thing that's hard about that is, you might sell a restaurant operation that has 20 or 25 locations. It has the same issues and problems of a restaurant operation that has 150 locations.
Mhm.
And so they aren't, you know, just because it's smaller, it doesn't mean they're any cheaper to deal with a lot of times. They're still the same issues. And so that's a hard sort of balancing act, is to know when to act and know when to step back, and make sure that you have sort of the light hand on the case so that you basically keep the patient alive.
Yeah, this case could have easily become administratively insolvent quickly. And one of the reasons it could have gone in that direction was the whole PPP issue. And Paul Hage, PPP was a huge issue in this case. This case was one of the first, if not the first, bankruptcy cases dealing with the use of PPP funds that were obtained pre-petition. What limitations, if any, does a debtor have with respect to its ability to use the PPP loan proceeds that it obtained pre-petition once the bankruptcy case has been filed?
Yeah, thanks, Sheldon. You know, we were talking in a prep call the other day, and the PPP program, there's lots of complaints about how that program has been rolled out, but it really did save this business. It was effectively the debtor in possession financing that allowed this business to have the limited runway it did to get something done there. And but for that $6.8 million in funds, most of which was still in the estate when the case was filed, we'd have a different issue. There's been lots of litigation in the bankruptcy courts all across the country about this issue of whether or not a debtor in bankruptcy can obtain a PPP loan. And there was a split in the case law. There's an opinion that went to the Fifth Circuit Court of Appeals, and there's good arguments on both sides about whether or not a debtor in bankruptcy should be able to get access to a PPP loan. I think the general rule now, the general thinking on this now, is that a debtor in bankruptcy cannot get a PPP loan. It's sort of where the case law ended up on that issue. But our issue was totally different from that. And that's because BarFly got the PPP loan pre-petition and then filed the bankruptcy case. And the issue there was, okay, now the debtor's in bankruptcy. Are there limitations to how the debtor can use this $6+ million of PPP funds in its bankruptcy case? So a little backup and just, recall that this was the SBA lending program. The SBA guaranteed 100% of the funds that would be advanced by the SBA lender. No collateral, unlike typical SBA loans. There was no collateral. It's an unsecured loan and no personal guarantees from the principals. The PPP program was created by the CARES Act, which was enacted in late March of 2020. And that act said that PPP loans are fully forgiven if the proceeds of the loans are used for certain allowable uses. And then the act defined those allowable uses. And it said allowable uses include, among other things, and it had payroll costs and healthcare costs, employee compensation, rent, these sort of types of things that PPP funds are generally used for. But it had that language that includes, among other things, at the beginning to it. And so our interpretation of the CARES Act is that the PPP loans, if they're used for those allowable uses, are forgivable. It can be forgiven, by the SBA lender and paid by the SBA. But if they're not used for allowable purposes, they can still be used. It's just that the debt's not forgiven, and the statute provides that the borrower has to pay back the funds at a borrower-friendly 1% interest rate. The problem was, in April of 2020, the SBA came out with a first interim rule that dealt with the PPP program, and that rule had a question on it that said, how can PPP loan proceeds be used? And it had a list of the permissible uses, but it didn't have, that list was narrower than what was in the statute and didn't have that sort of broad introductory open-ended language, quote, may in addition to the allowable uses set forth herein. It didn't have that language in the interim rule. And to make matters worse, the interim rule provided that if you knowingly use PPP funds for something other than the allowable uses, that you'll be subject to additional liability, including the officers and directors of the company, potentially, additional liability for fraud or misuse of the funds. And so the interim rule, different than the statute, put a real amount of pressure on the debtor and its management about how it used those funds. And it created a lot of confusion and uncertainty about how these funds can be used. If you use them for non-permissible or non-allowable uses, does that mean that it just simply has to be repaid, or is it something tantamount to fraud that can create personal liability where none previously exist? It was important in BarFly because BarFly needed to use, or HopCat needed to use these funds to be able to pay for rent and payroll and all that, but they also needed to use these funds to pay for hamburgers and food supplies and that kind of stuff. They needed to be able to use those funds to operate. And important to all of us participating on the panel, they needed to be able to use those funds to pay the professional fees of the case. So the debtors and the creditors committee took the position that I just said, that the allowable uses are just examples that are the key to forgiveness, but the debtor can otherwise use the funds, and if they use the funds for non-quote allowable uses, it's an unsecured claim. File your claim, it's an unsecured claim that will be dealt with in the plan. The SBA lender, which was based out of Ohio, objected and said that the PPP funds could only be used for the limited purposes set forth in the first interim rule. And they were objecting to every single filing. They were objecting to retention applications for estate professionals and interim fee statements and so on and so forth. So this issue got teed up in court. The debtors and the committee argued that, look, under bankruptcy law, it's property of the estate. No doubt about that. Property of the estate is defined very broadly. And the only exception sort of to property of the estate is if there's some sort of a trust relationship. And there's no express trust that exists with respect to PPP funds under Michigan law. Constructive trusts under Michigan and Sixth Circuit case law, very, very hard to get. And so these funds were property of the estate. There's no trust that existed for them. And as such, the debtor could use them free from any restrictions. And then we also argued that, when you looked at the CARES Act, the best interpretation of that is that the funds could be used for non-allowable uses. Again, it just meant that they wouldn't be forgiven if you used them for those purposes. And there's all kinds of arguments about, the SBA perhaps exceeding the scope of its authority when it created that first interim rule, and the Chevron factors, if that comes out of the Supreme Court case law and whether those applied. But our argument was basically the limitations that the SBA lender wanted to put on these funds, they were not found either in the bankruptcy code or in the CARES Act, and that should govern. This issue got teed up because of, again, objections to the professional fees in the case by the SBA lender, who said, can't use the estate funds to pay these expenses, and if you do, you're creating personal liability for management. And so the debtors, in another example, sort of collaboration between the professionals in this case, we worked with John's firm to brief the issue, and we argued in front of Judge Boyd in Grand Rapids, and he said, well, these are interesting issues, but this really needs to be teed up in the context of an adversary proceeding, as opposed to the concept of an objection to professional fees. And so again, we worked over a weekend to prepare an adversary complaint and get ready to file an adversary proceeding to tee up this issue. Ultimately, it never got teed up. And that's too bad, because I think bankruptcy attorneys all over the country were following BarFly for this very issue. We were going to be the case of first impression on these arguments about the limitations on PPP funds. We ultimately didn't tee it up because, as we're going to talk about in a minute, the sale process kept getting delayed and adjourned. And eventually we all came to the conclusion that if we win, we may spend as much money as is going to be left from the PPP funds by the time we get to the finish line. And moreover, the debtor really did need these funds because the sale process kept getting moved out. The debtor needed these funds to pay allowable uses, rent and payroll. And so we'd have to find some other way, some other mechanism to pay the professional fees. So ultimately, the issue never got teed up, never got decided by the courts, but it's a unique one, and one that I kind of wish we had gotten teed up, because there's lots of interesting arguments, without getting too deep into it, that could have been made really for both sides. The lender had excellent counsel and had made interesting arguments as well. And so it's just another example. The PPP has been a wonderful thing for a lot of businesses. It saved BarFly, but it hasn't worked really well in bankruptcy because of all these other types of issues, and maybe some other case that it will be addressed. To date, to my knowledge, the issue is still an issue that no court has opined on, at least in a written opinion.
Yeah, and I want to add to what Paul is saying on here. You know, in that contested hearing, and it was basically the lender objecting to some interim fee applications and whether or not the debtor could use the PPP funds to pay those. The judge denied the objection by the lender, you know, but then the judge wouldn't go a step farther and say you could use them for however you want and make a finding as to that. But the judge, I thought, said everything we wanted him to say, except making the finding sort of a prospective ruling. And so I think it was really clear that we were going to be successful. He was great over that. And sort of in my pleading with the judge to try to get him to take the next step, the irony of the whole thing was that the PPP funds were the thing that saved the business. And right there at that moment, we thought it was also going to be the very thing that was going to kill it, because we weren't going to be able to we were keep the case straightly solved. So.
Yeah, I want to make one other comment about it, which is to push back on this notion that seems to be reflected in the SBA regulations, that there's something inherently wrong about a debtor in bankruptcy, or that, as the SBA said in one of its regulations, that it's an inherently risky investment to make a PPP loan to a debtor in bankruptcy. I would argue that it's the contrary, because of course, if a loan's being made to a debtor in bankruptcy, there's all kinds of court oversight to make sure, and professionals, fiduciaries in place to make sure that the funds are properly used. Perhaps there's less risk in bankruptcy than there is in terms of loans to debtors outside of bankruptcy. And of course, businesses like BarFly that employed a lot of people, these are exactly the types of businesses that the PPP was designed to save. So I think the idea that the debtors and their management shouldn't be able to use these funds to save their business, I think that that's a mistaken one. This isn't fraud. This is exactly the type of business that all of us on this Zoom program do. It's trying to restructure and save the company. And that's the PPP funds, I think, should be freely usable to be able to do just that.
So, Paul or John, to your knowledge, has this issue come up in any other bankruptcy case subsequent to BarFly? And has, in that case, has the court ruled on the use of the PPP funds that were obtained pre-petition?
Well, I know two. They weren't before, but so there's a case in Delaware that was called U.S. Rugby. And in that case, the debtor applied for a PPP loan pre-petition, then was forced into bankruptcy, and then the lender funded it anyhow and didn't know. And so the funds were there, and so there was a bit of a dispute, but it was Judge Shannon, I believe, in that case, said some very positive things in sort of the colloquy in one of the hearings, in the first day or the second day hearing, where he said, hey, this is just a pre-petition loan. Like, but it didn't matter in the end because the company used the funds. And then there's another case in the Middle District of Florida called 2J's, which is a restaurant chain. And there was some racket from the lender there saying it had to be used for a specific purpose, and the judge sort of shook his head. But in the end, it didn't matter because they did use them for the specified purposes, and it didn't really become resolved. And I don't know any others. So.
Yeah, I know it's come up in quite a few cases, but I'm not aware of any opinions on it. It probably gets settled for the same reason in many of those cases it got settled in BarFly. I do remember being on an American Bankruptcy Institute webinar, I think at one point last summer, and they pointed to BarFly and said, this case is going to resolve this issue for everybody. And unfortunately, we let them down. We settled, so.
Okay, thanks guys. I just want to remind our attendees that you can ask questions, which we'll do our best to get to. And I just saw one pop up in either the chat box or the Q&A box. But before we look at that question, I want to shift to James. James, in many respects, the company was trying to navigate uncharted waters, as Paul just went through relative to the PPP loans. What were the committee's goals, and how did COVID influence the committee's approach to the case?
Sure, thanks, Sheldon. I think our goal from the outset was to find a way to keep this company moving and keep it going, because it was going to be the best for our creditors in general. The majority of our creditor dollars were subject to cure, so assumption of those would be very good. The largest creditor pool was the lessors, and obviously in a bankruptcy environment, a COVID environment, there weren't going to be tenants lining up to take the place of the debtor, and there was not going to be retrofitting of the space. So we wanted to keep those lessors with a tenant. And finally, we want to get some recovery of some type for some of the smaller creditors as well, and keep them with a customer to work with. So at filing, the company indicated that it was looking to do a quick sale with the secured lender as the stalking horse bid. And that's where COVID comes in at the beginning, is looking at that quick sale. A quick sale would have taken us into early fall. And if you'll recall, in the time period, there was huge concern over, the COVID surge in late fall. The outdoor dining would stop. What would a COVID surge do to indoor capacity? So, trying to get the business sold before any of those factors started adding up was key in our minds. But beyond that also was just the simple fact we talked about before: how is this going to be financed for anything but a quick sale? So all aspects pointed us to supporting that, but COVID was a dark horse hanging over. And we were somewhat hesitant, as you normally are, with that a related party entity was kind of stalking horse to start. But Robert ran a great process, got us really comfortable. That was a fulsome arm's length transaction, and it got us happy with that. I'll get to one of our goals in a second, but our typical duties, again, looking and maintaining our finger on the pulse of the sales process. Robert was great in giving us constant updates and really showing us where the tenor negotiations was going. And cash as well, monitoring cash, what's coming in, what's coming out. And we tried to keep our hands off as much as we could and let them do their business. It's interesting when you start talking about COVID, you talk about with cash flows being sensitive to variances and what's going on, and you've got to kind of reset your goalposts. I mean, Paul Neitzel and his team did an excellent job with their cash forecasting, but realistically, you're looking at a scenario where you've got a big plan for your two biggest restaurants going into Thursday, Friday, Saturday, Sunday of a great weather June weekend, and Wednesday night you get 2 positive COVID tests and they're shut down. Asking someone to forecast out 13 weeks when, 7 days from now, the receipts, we have no idea what they're going to be potentially, is a tall order. So I think, COVID, influenced kind of how sensitive we were and how much we want to tear into variances and understand those things. And that kind of leads me into some of our goals with the creditors and how COVID impacted that as well. One of our chief concerns was that the secured lender was sort of piggybacking off some of the value in the estate to get a deal done. And we wanted to make sure that we took care of our creditors and make sure they were compensated for that. One of our chief concerns was admin claims getting paid. This was looking at a sale and conversion to 7, and we wanted to make sure that all those admin claims would be taken care of and liquidity wouldn't disappear. So again, this was working with Paul Neitzel and his team to forecast what was going to be out there and what was going to be available to pay it. And with the COVID variance, I'd call it, again, risk-adjusted conservative views to make sure COVID didn't impact what was going to be there. So we were very conservative, and they worked with us to get to a number that made sense. Other goals of our constituency, we did feel that there should be some level of compensation paid to our creditors in this case, and we knew it wasn't going to be a big cash payout. So we were all able to secure a litigation seed funding. Basically set aside money that, upon conversion to 7, the trustee can look at using that money to potentially get recoveries that wouldn't have been available within the estate dollars going forward, or they can distribute those funds if they don't feel they're worthwhile to pursue litigation. And part and parcel of that, maybe even bigger, we were able to secure a deficiency claim waiver for the secured lender. So their $12 million waiver, I believe it was, cut the creditor pool by at least 50%, depending upon some of the SBA forgiveness and how that works out. But at the end of the day, that seed funding not only became available, but it was worth 2 times as much to the people that were still left over after that deficiency claim. And on that deficiency claim, I do want to give a quick shout out to Paul Hage, as well as Michael Brandis and Lisa Bandestieg at Sugar Felsenthal in Chicago, who were just dogged in making that happen. It was very important to us, and they did a great job.
Well, it would take far less money to get some sort of a distribution for unsecured creditors. Somebody asked a question, did the lenders take a haircut? And yeah, they took a huge haircut. They were owed $30 million, and the credit bid amount was, well, far less than that, maybe half of that. I just don't remember off the top of my head, but it was a big haircut. And so, you know, the way the bankruptcy code normally operates, then they'd have an unsecured deficiency claim, which would dominate the unsecured creditor pool. So it was very important to the committee to get that deficiency claim to be waived. Pay the freight, that's an argument, you know, the paying for the administrative expenses, James talked about that. That's an important argument for a committee in every case. But there's one other objection or one other serious concern that our committee body had that's kind of unique given the circumstances of this case. The committee believed, and it may or may not have been true, but the committee believed that the secured lenders who ended up credit bidding and operating this business, they believed that the debtors did not, or the creditors, the lenders, did not really want to own this business. That's why the sale process got delayed. They were just on the hook because they had such a large secured claim. And so we were very concerned about if this sale process results in a credit bid, will the lenders adequately capitalize this business going forward so that it can survive? Because of COVID and the things that were happening and the difficulty of finding buyers in the middle of this crisis, our definition of success in the case necessarily had to change from what it might have been in a pre-COVID type case. Success became get something for unsecured creditors, but sell the business and save the jobs and help facilitate that happening and getting a waiver of that deficiency claim. But that the saving the jobs and keeping the contracts and the leases, that's hollow if the company is going to end up in bankruptcy again 6 months later. So the committee made an objection that was sort of like a feasibility objection in the context of plan confirmation in Chapter 11, or adequate assurance in the context of an assumption of a contract or lease, and said, we need to have some certainty to the court needs to have some certainty that this business, if it is a credit bid that ultimately comes out of the sale process, that it will survive. That, you know, a hard thing to give, but we wanted to make sure it was adequately capitalized, even though, again, those are plan confirmation type concepts, not really 363 sale type concepts. We pulled those into the sale objection process and got some assurances from the lenders that it, you know, that it would be adequately capitalized, and hopefully, you know, going forward, it turns out that there was enough, and it is a successful process.
Thanks, Paul and James, for providing the committee's perspective on the case. Shifting gears here to, I think what we all felt was just a wonderful job done by Robert Hersch and his firm. Robert, maybe you can set the stage for everyone and tell us what was the difference in buyer tenor pre-COVID versus during COVID, and what challenges did you face in selling the company?
Thanks very much, Sheldon. I just want to address one thing that Paul said. It may be a little nuanced. The question was, did the lenders take a haircut? And I think traditionally the concept of a haircut is a cash recovery below face value. In this case, the lenders wound up with the asset, and they believe that the asset in the future has full value of their loan. So I'm not sure they've taken a haircut yet. It may be a pending haircut, but they, by virtue of the credit bid, own the business. But to address your comment, Sheldon, typically when we do a marketing process, even for a distressed asset, we have a 50% response rate, meaning 50% of the groups that we go out to are interested in the opportunity. On BarFly, we sent out 191 teasers on the transaction, and we had an 80% reject rate. That's almost unheard of, or a 20% success rate. So the reason in this environment was the lack of visibility to the end of COVID. So remember, we were after the March, April, May height of the pandemic, but we were into the summer kind of surge. So the tenor of the buyers, I think everybody in this case did their job. The lenders were prepared to pre-filing, to invest money, to buy out of leases that Rock Creek had identified as being overly onerous. Management was going to cut G&A. There was a path out of bankruptcy. And yes, why does a company that takes $6 million in PPP funds have to file? And it really was simply to protect the leases from termination by lenders. And the period of COVID was unknown. So the biggest issue was a restructured BarFly a good company. It was a good company. You had cut out the locations that didn't perform. We had gotten it down to kind of 11 core locations. Management, Rock Creek, Mastodon, everybody was in agreement that those were the kind of right, even the founders were in agreement that was the right kind of go forward footprint back to the core Michigan stores. But the question was, how long was the environment going to be negative? And that was the issue that ultimately led to the credit bid, was buyers were just not willing to fund a negative burn into an abyss in an indeterminate period of time.
So how robust were the bids that you got on the sale?
So the process was less robust in terms of the number of participants. However, the last men standing were very, very aggressive. There was approximately a half dozen groups that aggressively wanted to own this asset. And when you have a credit bid, which was limited, there was an opportunity to generate a value to top the credit bid. But given that you had to fund the losses as well as kind of buy the assets, we couldn't get the groups to kind of get to the number that persuaded the lender not to continue to own the assets. So instead of taking a haircut today, the lender wanted to own the assets for the future. But the groups that engaged in the process really saw the future value of BarFly as a restructured asset, and were willing to take a risk on the vaccine, which was not approved at that time, and reverting to a new normal.
So with these aggressive bidders, and I remember there was like two that it really came down to, that they were really close in their bid. But why did the sale ultimately end with the lender credit bid winning?
Yeah, so I think the lender wanted to own the asset. I think they kind of, let me put it this way. The lender didn't want to lose the asset at a discount. They believed strongly in the future value. They had the luxury of the PPP money, and now we know PPP2 and Restaurant Revitalization Act money. So they believed in the management team and believed that funding the losses with the assistance of government assistance, was worth the risk to try to recover fully. And the groups that were, and I think this is one of the key nuances, the groups that were bidding, they were bidding cash, real money to the lenders to take recovery, and they were bidding rollover debt to the lenders. So the lenders would have had an opportunity via that debt or equity participation structure to get whole, but they wouldn't have had control. And I think the lenders said, if we're looking for, if we're taking equity risk, we want equity returns. And they didn't want to roll over their debt for another management team and only recover their debt. They believe this company's worth a ton in 2022 and 2023 as a restructured enterprise, and they wanted the upside.
Sure, and yeah, but maybe you could talk a little bit about how the market changed during the course of running the process. I mean, the obvious one is pre-COVID, post-COVID, but even during COVID, were there any changes that took place in the market that drove the sale process the way it ultimately went?
I think there were two drivers of perception by bidders. One was progress on the vaccine. There was nothing organic to this business, to BarFly, that was different than a million other bankruptcies during COVID. Yes, Michigan was very restrictive. The company did not have a historical off-premise business, but substantially the factors for bidders was, when is COVID a thing of the past? When are we back dining indoors? And how much government assistance would be available post-emergence from bankruptcy?
Okay, and we're up against the hour here, and it's 5 o'clock is our hard stop. So I just want to open it up to all the panel members. If anyone has any comments on your view of the case overall and the thoughts that you'd like to leave our attendees with.
Well, to me, it was all of the professionals working together to try and make the best out of a very difficult situation. And the epilogue here is that there was a sale. There, the business continues to operate. It was acquired by a credit bid by the secured creditors, and jobs were preserved. That's the type of work that we all like to say that we do. The Unsecured Creditors Committee was able to carve out some funds as part of a settlement of a sale objection to be able to investigate and pursue causes of action, hopefully make some meaningful distribution to creditors. Leases got assumed, contracts got assumed. So we had to navigate. It was sort of a constantly changing environment that the case was going through. But I think, looking back on it now, it came out as a successful result from all parties, in large part because of a lot of communication and collaboration.
I agree with Paul. I would just add one additional point, which is restraint. And I think John Lucas with Pachulski and the lenders and the creditors committee and their attorneys all chose to realize the goal of their constituents and their obligations, and restrained what you see in some larger cases where litigation for litigation's sake. So I think it was a very good process, benefited all the constituents in the way it should.
Yeah, and one other thing, and we already said this one time, Triple P, it worked.
Yeah.
There was a huge government program to set up Triple P, and this is at least one instance where it paid off.
Yeah, and the one party or member of the professional team isn't on the panel, and that's anyone from the law firm at Sugar Felsen Fellow in Chicago. And I just want to say that they did a wonderful job as well, and they should be recognized as being part of the professional team that really made this case a success and a great outcome. One of the things that happened a few weeks ago is the Washington Post wrote an article on what's going on in the restaurant industry. And I don't know how BarFly became the centerpiece of that article, but if anyone's interested, you can look that up in the Washington Post. It's actually a really good explanation done by the Post on what's going on in the industry and how the industry has dealt with the pandemic. So on that note,
Can I make one other note, Sheldon, before you wrap up?
Go ahead,
One
John.
other important piece, I think, of what happened here is mediation, because there were strong arguments that were thrown about by a lot of different sides in what Judge Boyd at the sale hearing, and what Judge Boyd in Grand Rapids said was, I'm going to send this to mediation. He appointed Judge Gregg, John Gregg, his colleague on the bench, to serve as the mediator. And we went through nearly a week of on and off again mediations to get to the point where we settled this. But I think that's an important part of it and in doing so saved, I think, a lot of money. And so, when you get to the sale hearing or the confirmation hearing, there's a big battle. Consider mediation as a way to try and address those issues. Because in our case, I think it was quite successful.
I mean, and what the judge did there was, he says, we had a contested sale hearing and we didn't have a solution. And the judge is like, I'm sending this to mediation. And we said, when? And he's like, in 30 minutes.
Yeah. Via Zoom.
Yeah. In 30 minutes, you're going to a mediation. You're going to get a link in 30 minutes. Go get to work. And it was, I really have to compliment the judge for that. He did a great job of handling that. So. And
Paul, thanks for bringing that up. We didn't address it over the last hour, so I appreciate you bringing that up in the end, because it was a very important part of the case. And with that, I want to thank the panel members, Paul Neitzel, Robert Hersch, Paul Hage, James Morden, and John Lucas, for their contribution, not only to the panel today, but the wonderful job that they all did during the case. And that there is a networking event occurring on a different link starting now. So I want to thank everyone for attending. Hope that you all got entertained and learned something today. And it was a pleasure moderating this panel of distinguished professionals. With that, thank you very much.
Thank you, everybody.